law review, and it is my honor and pleasure to introduce Professor Barbara Creel, a member of the Pueblo of Habeas and faculty at the University of New Mexico School of Law. Prior to joining the faculty at the University of New Mexico, Professor Creel served as an assistant federal public defender in the District of Oregon, where she developed an expertise in habeas corpus practice and post-conviction relief. As a public defender, Professor Creel also assisted in the defense of Native American clients on cases from reservations under the Major Crimes Act. Professor Creel developed an interest in Indian law at an early age and has followed this interest through positions at the Native American Rights Fund as an undergraduate, as a legislative assistant for the National Advisory Council for Indian Education following law school, and as part of the Native American program of Oregon Legal Services. Today, Professor Creel will discuss the failure of the right to counsel under the Indian Civil Rights Act and the U.S. Constitution. While the U.S. Constitution does not apply to tribal courts, Indians appearing in federal court are subject to the guarantees of the Constitution. This creates an interesting and often confusing juxtaposition of rights under two very different systems. Professor Creel will discuss her article on access to counsel for indigent Native Americans facing legal proceedings in tribal courts and help us to better understand this issue. Thank you, and please help me to welcome Professor Barbara Creel.
Good morning. Thank you for that introduction. And I also want to thank the editor-in-chief, Robert Green, and Stacey Mazzara for their work on the symposium. It's really impressive. Thanks for including me. I am honored to be here today. Again, my name is Barbara Creel. I am an enrolled member of the Pueblo of Habeas, one of the 19 tribes in Pueblos in New Mexico. There are 23 tribes that have land holdings in New Mexico. And I am very proud to be here to be talking about the access of the right to counsel in tribal courts, or the lack thereof. That's really what we want to talk about today. Usually when I talk about my work in the right to counsel, I don't have the kind of audience that I have today. People that are interested in the issue on the civil side and knowledge of the issue on the criminal side. When I talk to Indian law scholars, people that are prominent in the field, people that have written books, treatises, law review articles that teach, that are professors that hold chairs at major universities, they ask me the area that I work in, and I said the right to counsel. And they laugh. And they say, there is none. And that's literally the analysis, the end of the story in tribal courts. When I talk with tribal leaders, tribal leadership, people who are working at the very highest level of Indian tribes, and I say if I work in the right to counsel, they say that's an affront to sovereignty. That is an insult to our sovereign powers. So what I want you to take away today is that there are people, citizens of the United States, original inhabitants of this land that we call the United States of America, who have no right to counsel. Yes, we're talking about the civil right to counsel expanding on Gideon after 50 years, the failures of Gideon, the promise of Gideon, all of those issues. But what we need to know from this particular talk is there is no right to counsel under the United States Constitution and the Indian Civil Rights Act for Native Americans. That seems surprising to many people. Sometimes it's the first time that they hear that. And so what I want to talk about today is, how did this happen? How did we get here? How did we get to a point where Native people themselves, or the leadership in tribes, are saying there shouldn't be a right to counsel? And the United States Supreme Court and people, constitutional scholars are saying that, oh, that's tribal sovereignty issues. We don't need to pay attention to that. Even when they're interpreting their own United States Constitution and the progeny that came from all the different Supreme Court decisions with regard to the United States constitutional 5th and 6th Amendment right to counsel. So how did we get here? Yes, how many people knew that the United States Constitution doesn't apply to Indian tribes? Basic tenet of federal Indian law. Still really surprising, right? We think that the U.S. Constitution applies throughout the land. It does not apply to Indian tribal governments. And that is because tribal governments pre-existed the U.S. Constitution. They weren't incorporated within it. There's a whole line of discussion within the Indian law world that talks about whether it should or it shouldn't, but we go back to a case in 1898 called Talton v. Mays, in which a Cherokee person was facing the death penalty and was seeking to challenge his conviction in a Cherokee tribal court. The Cherokee Nation had become assimilated, had worked with the United States government to create a government that would coexist, that would work on each other's sovereign powers. It was a nation-to-nation idea, but it really was one of cooperation. In adopting the United States constitutional American-style justice system, they took on a Cherokee tribal court. They also adopted their own constitution. Under the Constitution, they had a different grand jury requirement. The Cherokee person who was facing criminal conviction and the death penalty in a Cherokee Nation court sought to overturn the conviction, saying that the grand jury requirements didn't meet the United States constitutional requirements. And in that case, the Supreme Court said, they're different governments. This is the Cherokee Nation, and this is the United States Constitution. We have a Fifth Amendment grand jury requirement under the United States Constitution, but we don't use that to interpret Cherokee law. If they've adopted one, they get to decide what that is. This is not something that we're going to step in and decide for the tribe. It is a separate sovereign government, and on a nation-to-nation basis, we're going to honor that. And the Cherokee Nation is to decide what their constitution says and how it's interpreted. So there wasn't any review. There was complete deference to the Cherokee tribal court. There was also an acknowledgement of they're pretty much parallel universes, but we're not going to require the tribe to interpret or require the same things that we would under the United States Constitution if the same person was facing the same crime. And it's important to note that at that same time, the Supreme Court was looking at the state's requirements in Hurtado, in a case deciding whether the state had to rise to the level of U.S. constitutional requirements under the grand jury requirement. In that case, the Supreme Court said no. So it was kind of a parallel universe where the Supreme Court was saying, you know, we're not going to require this of states, and we're not going to require this of these other nations. So that made sense. If you look at that case in a tribal sovereignty realm, it also is very respectful of the Cherokee Nation, to the extent that it is allowing the Cherokee Nation to make those decisions of itself. But what I'm reminded of, and what I've written about in my paper, is that there's a historical context for this, in which every tribe is different. Every tribe had a different relationship to the United States government. There currently are 566 federally recognized Indian tribes. Federal recognition is a particular term of art that allows for that status of nation to nation between the tribal government and the United States government, the federal government. Not every tribe has had a cooperative or assimilative or adaptive relationship with the federal government and the U.S. Constitution. Tribes are here today because they've had their own individual path. There is a legacy for tribal existence that includes fierce resistance and resilience and a rejection of the United States way of life. Eventually, United federal policy with regard to the Indian moved over time. And that went from one of a nation-to-nation status, where tribes were dealt with as foreign nations through the treaty requirement. The United States Senate got to ratify the treaties with each and every one of the tribal nations that were in existence. In the 1800s, 1871, Congress ended that and decided to stop having an international relationship with tribal governments. The policy turned to one of allotment, asking the tribes to pick a certain area of land. We'll choose it for you. Stay there, and then we'll divide it up and have it doled out in a way that will allow the white settlers to also come in, and there will be more fruitful use of the land, more exploitative use of the land, and we'll be able to better control how the western expansion goes forward. After allotment, along with allotment came assimilation. Assimilation was the idea that tribal people as individual people should be joining the ranks of U.S. citizens in the same way as non-tribal people, that they should be cultivating the land, paying taxes, things like that. After allotment and assimilation didn't work as a way of federal control of the Indian, there became an idea in the early 1900s that maybe a different relationship with tribes might be helpful. One of supporting self-governments, self-determination, an understanding that tribal governments are capable of their own destinies and deciding what is best for the tribal people, and maybe the federal government should have a policy of supporting that. After that, there became an idea that, well, maybe tribes have a lot of resources, timber, minerals, land, that would be much more helpful if there was a better way to manage it. And then termination became the word of the day. In the 1950s, tribes were terminated. That's as serious as it sounds. They ended the nation-to-nation relationship with certain tribes in certain areas as an experiment. The experiment failed miserably. Things were worse off with those relationships. The tribal people didn't disperse out into nowhere, and they became, there was a huge problem. After that, again, the tide changed, and we're back to an idea of self-determination and self-government. But each tribe within that federal policy with all of the tribes is different and can't be said to have a particular idea of one way to deal with the government as right or wrong. Each tribe is looking at their justice system from their own lens. And it's important to note that tribes have justice systems in place when pre-contact, and those were not understood by the federal government. So when they sent Indian agents out into the new United States to meet with the tribal people, they saw only something that they didn't recognize. They saw tribal people working and operating along jurisdictional lines that they didn't understand, whether that's conceptual or territorial. And so there became an imposed way of operating justice in tribes. The first way to impose justice was to create an Indian police force in the 1800s, late 1880s. The Indian police were assigned to make sure that tribal people stayed on the reservations, stayed in the areas that they were required to, and basically didn't operate in lawlessness. The Indian agent at the time, in the late 1880s, decided that under federal policy, Indians being Indian was what their problem was. And so they wrote a code of Indian offenses that was actually a criminal code that was designed to teach the Indians how to be better citizens. It included a prohibition against speaking native languages, against dancing in heathenish ways, against what they saw as plural marriages, and had a whole regulatory system in which a tribal person would be punished by an Indian judge and sentenced in these courts of Indian offenses. The sentence could be hard labor, and usually was. It could be taking away the rations from that individual person or their family. It could be jail. In these courts of Indian offenses, it was decided from the very beginning that attorneys would not be allowed. Professional attorneys aren't prohibited. This is eventually codified in the Code of Federal Regulations. Courts of Indian offenses then became synonymous with CFR courts. Indian CIO courts and CFR courts are the same thing. It was an imposition of the adversarial system. The idea that within a tribe, the Indian agent could appoint sometimes an Indian person to sit as a tribal judge and act as a decision maker, act in judgment of Indian practices on the reservation. The Indian judges sometimes were paid, sometimes were given these positions as favors, as cooperative agreements between the Indian agent or the federal government. Sometimes they weren't paid. Sometimes they were just left to without any payment. The Secretary of the Department of Interior, which was actually under the War Department at that time, the Bureau of Indian Affairs was under the War Department, not the Department of Interior, decided that that was the best way to handle Indians, to impose these justice systems. Courts of CFR courts or CIO courts are still on the books today. They are in about 11 different tribes, and they continue on with this Code of Federal Regulations that allows for the operation and punishment of Indians on the reservation. The prohibition against Indians, against professional attorneys wasn't lifted until 1961. So from the very beginning, the imposition of the courts of Indian offenses throughout the 1800s, up until the civil rights era, there were no attorneys were allowed on the reservation to practice. And we're talking about whether this is civil or criminal matter. During the civil rights era, Senator Sam Ervin of North Carolina decided that he was going to look at civil rights abuses within his own state between the federal government and the Indian people. That was, some people say that was a way of sort of diverting the tension between the black-white civil rights question. And it really was something that started out from the idea that, well, what other people are there besides African Americans? There's the Indian people, and what about the civil rights abuses of Indians? So the Senate took on an extensive, comprehensive investigation of the civil rights violations or abuses or privileges of Native Americans within the United States under the U.S. Constitution. And they took on this issue of understanding whether or not the U.S. Constitution applies to Indian tribes. And the Congress was really surprised that the U.S. Constitution couldn't apply to Indian tribes. It was very, very adamant in the testimony. Years and years of transcripts. They did field hearings, they did Senate judiciary hearings, testifying, people coming and testifying before Congress about all the different ways that tribes could violate their own people's civil rights. But there's also a whole bunch of testimony with regard to the civil rights violations of Indian people at the hands of the state and the federal government. Stories of Indian people being locked up for being drunk on the street, being put in jail without being given an attorney, being driven to the edge of town in South Dakota and just left there in freezing cold weather to either die or to walk back. Nothing was ever done about those civil rights violations. Instead, the focus became, what does the Indian tribe do to operate vis-a-vis their individual tribal people? the discussion became, if the U.S. Constitution doesn't apply, we can't force Indian tribes to provide the monopoly of constitutional rights. What else is there? The compromise became the Indian Civil Rights Act of 1968. It set out, ostensibly, the entire United States Bill of Rights and said, no Indian tribe shall, and then set out 10 enumerated rights. One of those rights was the right to due process. No Indian tribe shall prevent or prohibit the right to due process. Essentially the Fifth Amendment due process clause that we know. It also included the right to a jury trial, the right to have compulsory powers to compel people to come in to an Indian court, to cross-examine people who are your accusers, the right to be free from cruel and unusual punishment, the right to free exercise of religion. It didn't have the establishment clause because tribes can be theocracies and can practice religion through their government. But it didn't prohibit the other types of assembly, petition, all the things that we know are covered under the Bill of Rights. What it didn't include was the right to counsel. So what the Indian Civil Rights Act said is that no Indian tribe shall prohibit due process, and Indian individuals can have the right to counsel at his own expense. Now we've already heard about the background of the right to counsel and how that impacts individual rights. And then we're now discussing how it expands to be required as a due process right in both the criminal and the civil arena. But what we had in Indian country, in tribal courts, was an imposition of the adversary system with a judge and a prosecutor, but with no right to counsel in criminal or civil matters. When the Indian Civil Rights Act was being debated, tribal people came to those hearings and testified, tribal leaders did, that it wasn't necessary. There was no need to impose the Indian Civil Rights Act because tribes could had inherent sense of justice and could develop this for themselves, or had already developed it, or the sense of justice just wasn't the same. We don't have this Western-style court system, and we have a circle, a restorative justice system, a therapeutic justice system, to put a more common word on it, or a more modern word on it, then there was a need for this Civil Rights Act. Other tribes came and said, we, Cherokee Nation and the 5 civilized tribes, we have constitutions. We've already adopted the United States Constitution Bill of Rights as our law. There's no need for this. The Pueblo people testified in unison, saying there is no need for this because it is completely a different concept. It is a concept that does not apply to us. It is something that will destroy our tribal way of life because it is so foreign that there isn't even really a translation. It's not necessary because our government doesn't operate the way your government does. And so telling us how to operate our government is just wrong. This made sense to a lot of Indian leaders and to Congress. It wasn't that they wanted to come in, Congress didn't want to come in and tell the governments what to do, but they did. So they passed the Indian Civil Rights Act in 1968 and left out the right to counsel as a deference, as a promotion of tribal sovereignty, as a way to say, you may not need attorneys, I don't know, we think they're a good idea, but we'll let you decide. And we're definitely not going to require them. And so some tribes took that to heart. Where I come from, in New Mexico, there are still tribes today who have a prohibition against counsel in court, in any arena, civil or criminal. because of that, because sovereignty became tangled up in the idea of the appearance of counsel, it became a sovereign prerogative for tribes to be able to say, no attorneys allowed. And tribes have held on to that idea very closely as a sovereign prerogative. And so wherever you go out through the United States, when I speak about whether Indian individuals should have counsel in a criminal matter, I always get that that's a violation of tribal sovereignty. Instead of understanding the history and how the tribal courts were hijacked to have this imposed adversary system, and then handicapped to be told they cannot have counsel, and then tribes adopted it themselves as an idea, that they were actually just being co-opted. They were actually just continuing the oppression that was brought on by the colonists. And that's not to say that tribes don't have a really good reason to prohibit counsel. Tribal history is full of negative implications, negative relationships between tribal leadership and professional attorneys, whether that be an Indian agent, a government leader, or an attorney who comes in and says, I'm here to help. There are definitely reasons that tribes should be suspect of a white attorney coming in and saying, I'm here, I'm going to take over your justice system, or I'm going to tell you how you're running your justice system wrong, or I'm going to, as people see me sometimes, just break all your criminals out of jail. When I work in Indian country in criminal cases, I usually say, when you work on the reservation, these criminal cases aren't a whodunit. It's not a matter of which person, did we get the right guy? It's usually pretty much cut and dried what happened. So process is the thing that matters. The due process clause under the Indian Civil Rights Act or the U.S. Constitution or the tribal law is paramount. It's the most important part. It defines how the tribe is able to operate in a just and fair system. When Indian individuals see that they don't have a chance, the sense of hopelessness is pervasive and it continues on, not just in crimes, but throughout their lives and their families' lives. I have a client today who had a case in which he faced a professional attorney in a tribal court before a non-law trained judge, and was convicted of basically domestic violence. It was a fight between him and his parents. It also involved some of his nieces. And it was an ugly fight. He tore up some furniture, he spit at one of his nieces, he was very disrespectful to his parents, and for that he got 7 years. He was convicted he asked for an attorney. The tribe didn't have to give him one. He asked for help. The prosecutor made some remarks on how well he was doing despite the lack of knowledge and despite the fact that he didn't have an attorney. And he got, actually he got 8 years. He got an 8-year sentence because he had these individuals' charges that he was convicted on, and then the judge stacked them together. And he went to a county jail for 8 years. I found him there after about a year, and we began the long road of federal habeas review. The Indian Civil Rights Act contains a provision, 25 U.S.C. 1303, that requires federal review, or grants the privilege of the writ of habeas corpus in federal court. During the litigation in the case, the tribe commuted his sentence. So then the issue became whether or not it was moot. The tribe said there's no longer an issue. Under clearly established federal habeas law, once the petition is in and you have meritorious claims in the fashion case, it's not moot. The issue becomes then whether or not he was wrongfully convicted. We took the case all the way up to the Supreme Court and they denied cert. The 10th Circuit said it was moot. There was nothing else that could be done. That is absolutely wrong. The problem with these cases isn't just that people get 7, 8 years in jail. it's that then those uncounseled convictions are used against them in the civil context, in a case to decide whether he should be a parent or not, whether he could have his kids removed. And then, even more importantly, even more egregiously, they can be used in federal prosecution under 18 U.S.C. 117, a prior uncounseled conviction of an Indian person in a tribal court can be used as a predicate offense to have a federal prosecution for federal domestic violence. This wouldn't happen to anyone else. It wouldn't happen to you or you or you if you're not a tribal member. Why not? Because Indian tribal courts don't have jurisdiction over non-Indians. So even though it's a sovereignty jurisdictional issue, it really is a racial issue. It really is an identity issue. Only Indians can be convicted in an Indian tribal court. It doesn't have to be the same tribe. It doesn't have to be the same Indians. Any tribal court can have jurisdiction over any other Indian that appears before them. So when you look at it in that lens, it is a purely racial issue. Only Indians can have those prior uncounseled convictions that then become predicate, essential elements of a federal offense. All of these issues have implications for the civil right to counsel, because if Indian people don't have a basic Sixth Amendment type right to counsel, then there is no way that there's the idea of expansion or even proper, competent right to counsel in any other arena. And then there are the ways that these prior uncounseled convictions are used in the outside world, by the state courts, by the county courts, and by the federal courts. So this is a huge issue. What the federal courts haven't understood and the Supreme Court hasn't reviewed is the idea that Indian people are United States citizens, and yes, they are dual citizens, they're citizens of their own tribes. But what is missed by the federal courts is that there's an interpretation of the United States constitutional right to counsel, and then there's an interpretation of a tribal internal right. In a federal court, the judges are evaluating whether or not the U.S. constitutional principles have been upheld. They are not being asked to decide whether the tribal law is right or wrong. And federal judges have got it right a couple times in the district court, but then were overturned by the 8th and the 10th Circuit, saying, oh no, tribal sovereignty, if they say there's no right to counsel, that's okay. There's no Sixth Amendment violation. Instead of viewing it through the lens of the U.S. Constitution and all of the clearly established case law that says there is absolutely a right. If another jurisdiction didn't honor that right, we are then disparaging all of that law if we don't uphold it, if we uphold a prior uncounseled conviction in another proceeding. That's something that really needs to be reviewed by federal courts and by the Supreme Court. I hope that I've given you a better picture of some of the anomalous complexities that come up between being a tribal person, being a tribal lawyer, and working in the U.S. constitutional and in the federal system. And I really do appreciate the opportunity to discuss these issues with you, and I welcome your questions. Yes, Professor.
I'm a tad confused, and perhaps it's because I came in late, but I understood you to say that we're not going to impose constitutional requirements, but we can allow the United States Congress to legislate in a manner that's going to impact tribal people. And then I start thinking about the Privileges and Immunities Clause, and as I teach it, I never figure out how to deal with it, but it seems you've just rolled out the place where Privileges and Immunities Clause under the 14th Amendment might be a place where you could get some traction.
In what way?
Well, when we go back to the original adoption of the Privileges and Immunities Clause, it basically gets gutted so that we don't fully incorporate the Bill of Rights as applicable to states. And there was this statement by the court that there are rights created by citizenship in the union that may not necessarily be vindicated when the actor is the state. But all of a sudden, as you're talking, I see, citizen, not a member of a state, Bill of Rights.
What else is there?
Got it. And the light comes on. Have you seen any litigation or any attempt to use the P&I clause of the 14th to try and get some of those constitutional expectations, or has that fully been
That's
closed
beautiful.
out?
That you're thinking in a way that a scholar, that a professor, a federal judge should be thinking. That has not happened. Because of the tangle, the world of federal judges thinking they're upholding sovereignty by disregarding constitutional principles. And because tribal people have never brought it up, we've never gotten to that level of analysis. And I hope that we will. There's a clause or a quote that I keep thinking of in a Troy Ide article. He's a former United States attorney in Colorado. He wrote an article called Separate but Unequal, talking about this issue. And he said in the Supreme Court discussion of Brown v. Board of Education that the attorney who was presenting at that time was being asked a question, how come more Native Americans don't bring these cases, these educational cases? And the white professor, counselor said, oh, we try to get them to, but they don't have the wherewithal. So we'd like to bring these more cases for natives, but they're just not there. And that's sort of I think that's a huge cultural gap. They're saying a lot in that one sentence. They're not there yet. They don't have the wherewithal. Part of it is just the ideas that I've spoken of already. The idea that we don't want to be in federal court discussing our issues. Another part of it is if there isn't a right to counsel, as you said, at the very basic level, there isn't going to be a record. And if there isn't a record, there's nobody paying attention. If there's anyone paying attention, there ain't nobody going to stand up for you and say, this is wrong. And so it goes. I've always been really lonely talking about this because I don't have someone to bounce it off of. So I really appreciate that. That's a brilliant idea. Other questions? Yes.
Given the history of colonization, especially in the Western Hemisphere, have you seen anything analogous to this process with Native Americans in the U.S. compared to other countries? Now, I have a feeling your answer is going to be considering our legal system in America that we actually are much more advanced than other countries, for instance, Aborigines in Australia, compared to Native Americans in America, are much less respected. But I'm just curious if there's anything analogous in the development of the legal systems internationally that we could look to.
I don't know if there is. I've worked in Australia. I talked with some clinical legal educators there. I work with a woman in British Columbia who works with the First Nations and the Métis. And I'm always surprised about the parallels when we start talking about the issues that come up with regard to colonization. Like, oh, you get that too? You do that too? The same concepts. And it's really affirming in that awful way that it's like, oh, that happened to you too. The boarding school process in Canada also happened in Australia, also happened in the United States. They have the same problems of just degradation and hopelessness that came out of that historical trauma. And there's a weird sort of solidarity that comes out of it, but there isn't a lot about how to talk about these issues from an international, criminal, or civil right to counsel way.
Because our system is so unique, is that kind of the purpose? And
not so much that the United States system is so unique, but that concepts of justice are different between tribal people and the Western world. And so if we're just going to talk about how well to assimilate tribal people, then the United States has done a really poor job within this justice system, because they're just now talking about these issues that we're talking about. And the tribal, I wanted to provide a little addendum to my talk, and that's the Tribal Law and Order Act was passed in 2010. Has a comprehensive overhaul of the criminal justice system in Indian country, and just now has a requirement for criminal counsel in order to sentence an Indian person in the way that my client did. It was sentenced to have those sentences stacked, so an Indian person can legally get a 9-year sentence if he has an attorney, and that attorney has to be law trained, and it has to be before a law trained judge, and has some other requirements. So the Congress is just starting to think about what did we do, and then the only way that they are fixing it is just glomming on the right to counsel at the end and saying, oh, but if you have an attorney, you can do this. It doesn't have talk about anything else about what a due process right even means without an attorney. Yes, sir.
I'm Professor John Britton here, and I've been married to a member of the Shinnecock Indian Reservation in Southampton, Long Island for nearly 44 years. And I'm familiar with everything you said, including I used to teach the Indian Civil Rights Act in my civil and political rights course. My question is, with the increasing number of members of nations going to law school and getting other higher degrees and coming back to their tribes and assuming positions of leadership, do you see any possible trend in the future that it's a delicate term, Americanization of some of the native tribes based upon the educational attainment of their members, changing any of these views, particularly on the right to counsel in criminal cases?
I know that the students that I work with, when we talk about these issues, and then we actually work in tribal courts and in federal courts, their eyes are opened, and they see how tribal governments operate as institutions, and how tribal courts can operate to be oppressive against their own, vis-a-vis their own individual members, if they're not thoughtful. And that's the first time that they've thought of that, because what they've grown up with, up until they start working in the world, is that tribal sovereignty means tribes get to decide.
That's right.
And there isn't a discussion that I know of from the individual Indian person's perspective. And that's not to say we don't have, there's huge debate in Indian law about whether or not we should have individual Indian rights, because it's tribes are communal and it's antithetical to the idea. But we're not talking about that. We're not talking about how Indians can be better Indians. We're talking about how once you've adopted this Western justice system, how then you are fair, how you are just, how you are principled, how you understand where it came from, what the writ of habeas corpus is or was, or what due process is or was in that other land that then gave you the system. My students are just beginning to have their eyes open, because nobody talks about this. Because as I said, Indian scholars just have kept it really close to tribal sovereignty means tribes don't have to think about certain issues. And so it's unfortunate. So I'm hopeful. I'm hopeful. Oh, I think there was a question here first, Professor.
My question was
Let's just do one more.
Oh, okay.
I was more just one of ignorance and maybe a very quick answer, and maybe Professor Khan's question.
Let's do two more.
My only thing was, I mean, you talked about the divergence into the federal habeas process, but I guess generally prior to that, I don't have any concept of, so you go to trial in a tribal court, you're convicted, but then is there an appellate process post that, and what's the body of, is there a body of review decisions by any like higher tribal courts that you pull scholarly?
Great question.
I just don't know what the actual.
Yeah, great question, because that's where you would go, right? You would look at the record. You would see how the internal process is. Every tribe is different. This particular tribe that I worked with my client had an appellate process that meant writing a letter to a consortium of Indian tribal appellate courts, and they just affirmed it. And that was pretty much the record. In another case, in the Tohono O'odham tribe in Arizona, they have a habeas corpus statute under their appeals process. And my juvenile client in that case, well, he was a juvenile at the time, he got almost 4 years on counsel and was stuck in New Mexico, and I found him there. I didn't go through that indigenous process because it was, he had waived all his rights. He had waived every right to appeal. Because it was under the appeal process, we went straight to federal court. The 10th Circuit said you have to go back to the tribe. And so that's where we are now. So I'm in this weird circle. But the answer truly is every tribe is different. There could be no appellate process at all. Yes, Professor?
Sort of a two-part question. One is, our criminal process is not necessarily a sane or humane process. And at least my work with Navajo said that there were more important traditions that needed to be preserved. And so I was wondering what attempts, so part one was, what attempts are being made to preserve that wisdom that comes from a non-punitive adversarial system? The second question is, what kind of quasi-political or organizing process needs to be done to start educating our judges or get scrutiny of the kinds of things that you're talking about? Because that was what started, had a triggering effect in moving toward tribal self-determination, but there needs to be continuing sort of almost expose of what our courts are doing to what was attempted.
I agree with you that the American system isn't perfect, and so I try to teach that to tribal leadership. What is being done with regard to preserving and promoting tribal indigenous justice system is up to the particular tribe. With regard to what the federal government is doing, it's nothing. They've only ever funded tribal police, tribal prosecutions, and now tribal jails. There's a huge amount of money in tribes build their own jail. And so there hasn't been that same fostering, oh, what justice system do you have? There is a little bit of room with regard to restorative justice, when they're saying, oh, they're looking to tribes now, oh, what is a sentencing circle? What is therapeutic justice? What would be restoring tribes? And that's where I think tribes can have the most act. I say sovereignty is what sovereignty does. Tribes can say, forget this Western justice system. We do it this way. We're going to have a juvenile discussion about what is proper punishment for this particular crime. With regard to teaching judges, leadership, things like that, it's the same. In the 1960s, they looked at, oh, what do tribal courts need? Oh, they need education for their judges, they need funding for their buildings and for their infrastructure, and they need people going to school. If you look at the same studies today, it's comical if it wasn't really true. Oh, they need funding, they need education, they need judges who have law training. Oh, where are we going to get this money? I don't know. When I testified before Congress on this issue, they said, well, who would pay for these attorneys? I said, well, Congress. Congress has imposed the Indian Civil Rights Act, and now there is a requirement that Indian attorneys, that there be more attorneys. If there's going to be a system where Indians go to jail, there needs to be a public defense system, and it needs to be funded by Congress. Thank you very much for your time. I hope I didn't go over.